So the Innocence Project, very, very important project, especially in Florida, so it happens to throw a lot more people into jail than most states. And you know, they have this new law that just passed that says the jury only has to have 8 people to not a unanimous, it doesn't have to be a unanimous decision for a death penalty case. So, and it tends to be obviously poor, non-white, Hispanic, and black people. We don't know. So Seth is going to talk all about that. I'm not going to get into it. But Seth is, he's the executive director of the Innocence Project of Florida. And he also, he teaches at the Florida State University College of Law. And he's also was president of the Innocence Network, which was a consortium of more than 65 innocence organizations in the United States and abroad. So he has a lot of great experience. I'm going to turn it over to him now.
Good morning.
Good morning.
I'm always gratified when I have to bring in more chairs. So thank you, and Sue, and thank you to all the Democratic Women's Club of the Villages for having me here, and our development officer, Jessica, who's in the back, so she will meet her as well. I will try to hold it very close. Okay, so it's really a pleasure to be here, and I want to start my talk here with a thought experiment, okay? So just bear with me. So I want everyone to close your eyes. We're not going to throw anything at you. Everyone's safe. Just close your eyes. I'm going to talk you through it, okay? So I'd like you all to think back to when you were about 18 years old. Maybe you were just getting out of high school, you're a freshman in college, maybe you're carefree. You might have had long-term goals, but you're probably really looking to figure out the trajectory of your life and figure out who you're going to be as a person. What did you see for your life? You probably went on, and if you went to college, you probably graduated college, got your first job. You might have met your life partner during that time. Maybe you were lucky enough to start a family. And over time, you might have progressed in your career. Maybe you bought the house of your dreams, or a number of houses, if you're lucky. You accumulated wealth and material possessions. Maybe you became a leader in your respective communities. And as and you also got a cell phone too at some point. As time has gone on, you might have been able to see your children begin a similar path of their own lives. You might have gone on to be able to experience the joy of not only being a grandparent or a parent, but also a grandparent, and for some of you, a great-grandparent. And think about all that you've experienced in those 2 to 3 or 4 or 5 decades since that point. They were, in many cases, the prime years of your life, of all of our lives, of maybe the best years. And now imagine that all just simply disappeared. That it never happened. Like someone plotted your life out on a spectrum and just extracted those best years, leaving a hole, leaving a void in your life. Everything that you experienced during that time would just be gone. And how would that make you feel? How would you deal with that? Would you have the strength to regain your life? Okay, now you can open your eyes. So, this is the experience of the men and women who are victims of wrongful conviction and wrongful incarceration. Their hopes, their dreams for their lives were extinguished because we, as a society, made a grievous mistake. And yet so many of these victims, with the help of organizations like mine that are designed to find people in prison and provide them free assistance to get them out, they finally achieved long-sought freedom despite a system that was hell-bent on depriving them of that deserved liberty. So in the short time I have with you today, what I want to do is give you a window into how it is that in a country with the self-described best criminal justice system in the world, where we have all the resources and scientific technology at our fingertips, how we can so frequently have system failures that cause innocent people to be disconnected from their families and from society. And so we'll do this by looking through the lens of my own experience as a lawyer and advocate at an innocence organization, the Innocence Project of Florida, who's had the honor to represent dozens of individuals who were left behind by the criminal justice system. So this is James Bain. This is his mugshot that was taken shortly after he was arrested for rape of a little boy in Polk County, Florida in 1974. This 9-year-old boy was abducted from his home. He was taken to a baseball field and he was raped. And then he returned to his family, who asked him to describe the man who raped him. And the boy's uncle, who was there, was assistant principal at the school, heard this description and thought, that sounds like one of my students, Jimmy Bain. So he went to the school files, pulled the school picture of Jimmy Bain and provided it to the police, and it was made part of a lineup. And when the boy was shown the lineup, they didn't ask him whether he saw the person who raped him. They asked him whether he saw Jimmy Bain, who lived nearby. And of course, he was identified. And based on, pretty much exclusively on that terrible and unseemly, suggestive identification, James was convicted and sentenced to life in prison at the age of 19. He left behind his siblings, including his twin sister, and when the judge announced that life sentence, his mother fell to the ground weeping and crying, and she had to be removed from the courtroom by the bailiffs. She was so distraught. Now, for more than 25 years, James sat in the prison. He just sat there. He figured he would die there. And in 2001, however, he began 4 separate attempts over 8 years to try to get DNA testing after Florida passed a DNA testing law for people like him. And Mary McFadden, you worked at the court, so you'll know what I'm talking about here. Each time, the court gave a different excuse why he couldn't get the testing. First, it was that he didn't use the right words in his handwritten motion. The next time, it was that his motion was not filed on time, even though there was no deadline to file. The next time, it was that the evidence couldn't be located. And the last time, it was that the trial transcript was destroyed, so the prosecutor couldn't effectively defend against his claim for post-conviction DNA testing. Each time, neither the state nor the court made any effort to procure this vital scientific testing that could prove his innocence. And that's when my organization, Innocence Project of Florida, got involved. And we're a small, nonprofit justice organization in Tallahassee, and our goal is to find innocent people in prison, free them and help them rebuild their lives, and of course improve the criminal legal system to prevent wrongful convictions in the future. And we were one of about 60 of such organizations in the United States, and there's many across the world. We all do this sort of needle and haystack work. So after almost 35 years of fighting for his freedom, our efforts in the case gave him his first progress, and in December of 2009, a mere 8 months from when we got involved in the case, the DNA testing results came back and showed that he was not the person who raped that little boy in 1974, that he was innocent. And 14 years ago in December, can't believe it's been that long, already 14 years ago in December, James heard the words that he'd been waiting to hear. Mr. Bain, you are a free man. And that is a younger version of me. No gray hair at the time. So he walked out with me and his other lawyer, Melissa Montel, at the front door of the courthouse into the waiting arms of his two sisters. The one who you can't see is his twin sister. And so when James went into prison in 1974, it was before Richard Nixon had resigned. And when he came out, we had a black president. Okay? So you can tell the difference in time here. A lot had changed. Here is James trying to use a cell phone for the first time to call his mother who couldn't get there that day. What you can't see in the picture is he held it upside down first. I'm like, James, it's just a phone. It's just like the phones you had. 35 years is a long time, and here I was only 30 when James got out, but he's made the best of his time. He's gotten married, and this is his stepdaughter. And in fact, him and his wife have a child of their own. This is, he was born in 2012, so this is an old picture by now. But yeah, so he never thought he'd have a child, and here he is with James Jr. Now, exonerations are sort of surreal experiences. The idea of freeing someone who was set to die in a cage is both odd and wonderful. My team at the Innocence Project of Florida has had the opportunity to literally give 30 individuals that new lease on life. But while these moments are important for the men and women we help as well as their families, they're singular moments. In some ways, the far more important work that we do is answering the question of what can we learn from these total system failures? How can we use what we learn to change the system to try to prevent other people from experiencing what James Bain experienced? And James' case presents one of the more egregious misidentifications leading to wrongful convictions of an innocent person. One of the upshots of having so many wrongful convictions and exonerations is that we have a very large data set in this country of known exonerations since 1989, more than 3,300 of them. And a subset of those is about 380 DNA exonerations. And we've learned that eyewitness misidentification is the leading cause of wrongful convictions in the United States, and that misidentifications have led to about, in 70% of the people who've been exonerated by DNA testing, they've had at least one or more misidentifications in their case. And so in these live or photo lineups, the person who is the known suspect is supposed to be included in the procedure with others who look like him or her. But all too often, the lineup's composed in such a suggestive manner where the known suspect sticks out. So I didn't have this, just an anecdote, I didn't have this slide in, but I put it back in just for you. The last people I talked to with this presentation must have been a little prudish, but I knew you guys would be okay. So when someone sticks out in a lineup, it makes it more likely that the witness picks him regardless of whether he's in fact the actual perpetrator. Now, to take the suggestiveness out of identification procedures and make them more like scientific tests of the eyewitness's memory, we've worked with law enforcement, prosecutors, the courts, and legislators to promulgate scientifically sound procedures for doing lineups. And we've done this in statute, by the way, in 2017. Now, lineups should be treated like we talked about drugs here, we talked about pills, right? Lineups should be treated like drug trials, where the administrator of the trial gives the subject the drug, and he or she doesn't know which are the placebos and which are the real drugs. That's both the administrator doesn't know, as well as the person who's getting the drug. This double-blind test, is what it's called, is done to prevent intentional or unconscious clues by the administrator that might improperly influence the responses of the subject. This was the one I put in for the proof. So I also kept it for you. Now, the same applies to photo lineups. In more than 20 states, my colleagues and I have passed laws implementing double-blind lineup procedures that require the the use of an independent administrator who doesn't know whether the suspect is in the lineup or not. This prevents cues and what we call post-identification feedback, like, do you want to keep looking? Which sends a signal that you didn't pick our person. Or, you did a great job, which sends a signal you did pick our person. And these can influence the witness both at the lineup and inflate their confidence in their identification so that when they get to the trial, they say, that's the person who I saw commit the crime. I'll never forget their face. It's seared into my brain. And as we can imagine, that's a very compelling to a jury. So we're leveraging the lessons of past miscarriages of justice to change the way we do things to prevent convictions in the future. This is my client, William Michael Dillon. He was convicted in 1981 of a Brevard County murder when he was only 21 years old. And you're gonna laugh when you hear this, but it's true. His conviction rested heavily on a number of pieces of evidence, including the testimony of a legally blind eyewitness, a supposed jailhouse confession relayed by a serial informant who we now know has helped wrongfully convict a number of people, testimony of a girl he was then seeing who had an illicit affair during the investigation with the investigating detective. It would be funny if it wasn't true. And evidence by an infamous fraudulent dog handler who tainted dozens of Brevard County cases, who said that his dog could smell something and then find that scent anywhere in the world, including at the crime scene. So Bill languished in prison for decades, but then he saw some news clippings on a man named Wilton Dedge, another one of our clients. And Wilton's case had very similar issues. It was in the same county, had a jailhouse informant, had the very same dog handler, who is by that point run out of town because he's a fraud, and Wilton was exonerated through DNA testing. So Bill petitioned the court on his own for that DNA testing in 2006, and we came into the case and got the testing on the bloody t-shirt that was left behind at the scene of the crime by the perpetrator at the murder scene. And it proved, that DNA testing proved that Bill was not the person who murdered the victim. And Bill's conviction was overturned due to that exonerative DNA test results, and he was released after 27 years of wrongful incarceration. And as he walked out of prison, Bill was joined by his lawyers and reunited with his parents and his siblings and his many supporters. Now, DNA testing has the ability not only to prove innocence, but also to prove that purported evidence of guilt was wrong in the case. And here, the DNA evidence proved that the jailhouse informant fabricated a jailhouse confession supposedly given by Bill, and confirmed what we always thought, that that dog handler who said that Bill's scent was on that victim, on that shirt left by the perpetrator, was actually a fraud and a charlatan. DNA testing has changed the way that we view other forensic sciences, and it caused us to question whether forensic methods like bite mark evidence, like pattern ballistics, and many others are even reliable. And it's had such an effect that the National Academy of Sciences issued a landmark report in 2009, and President Obama's it's the Presidential Commission, it's PCAST, on science and technology. They also issued a report subsequently lambasting the current state of forensic science and concluding that besides DNA testing, most of the other supposed forensic sciences actually lack scientific validity. So just think about that. Think about that. The entire field of supposed science that the criminal justice system has relied on for decades to prosecute people and remove them from society lacks scientific foundation to be reliable. So, while John Preston and dog handlers like his, he's a dog handler in this case, might not be in frequent use, many of those unreliable methods are still in use. They're still used every day in cases in every corner of this state and this country to take away the liberty of folks, some of whom might be innocent. So there's an effort underway to strengthen the reliability of forensic evidence to better equip courts to weed out those supposed forensic sciences that are unreliable. We're making great progress toward limiting criminal trials only to that evidence which has sufficient indicia of reliability. And of course, DNA testing has had one important but less notable residual effect. So every time someone is wrongfully convicted, they are separated from their families and society, and that, of course, is a tragedy. But the corollary to that is that when someone is wrongfully convicted, the real perpetrator remains out on the street to prey on society. So of the more than 380 people nationwide wrongfully convicted and later exonerated by DNA testing, so it's just a small subset, about 10% of the overall exonerations, in more than 150 of those cases, organizations like mine were able to identify the real perpetrator. Most recently, in a case out of Tampa, that Andrew Warren, who many of you know, agreed to exonerate the person with us, and then he was shit-canned by our wonderful governor. Okay? That office is now prosecuting the people who committed the crime that Robert Dubois was exonerated for. So those real perpetrators, after the wrong person was convicted, were left free to commit more than 75 rapes, 35 murders, and 35 additional crimes. So the detriment of wrongful conviction is not only limited to the immediate folks in proximity to that wrongful conviction, but it affects safety in our community as a whole. So luckily, in Bill's case, the DNA on that t-shirt was matched to an individual who, with two other individuals, actually committed this crime. We found the real perpetrators. And in 2012, the state of Florida passed a bill compensating Bill Dillon for the 27 years he spent wrongfully incarcerated. And here he is with another one of our illustrious governors. Maybe the greatest thing Rick Scott did during his time as governor was sign that bill. If you can bear with me, I'll tell you, since we're in such a group of wonderful, incredibly political Democrats here, I will tell you a quick anecdote about Rick Scott and wrongful conviction. So, which I told at dinner last night. Before this moment, me, Bill's wife, and my staff attorney at the time, Melissa, who you saw in the earlier picture, we were invited back to a sitting room where we sat with Rick Scott and his wife. And it was lovely. He was very nice. He's a little awkward, but he's trying to be very nice. And so, at one point, he leans over and he puts his arm on Bill's arm and says, "I know what you went through." And Melissa put her arm on my arm and dug her nails. And he said, "I know what you went through. The government came after me too and persecuted me." And we smiled, and yes, we smiled and we nodded and we left, and then screamed and we left. But think about that for a second. This is so out of touch. The government persecuted him, and he got to become governor and now senator. The government persecuted Bill Dillon. He lost the 27 best years of his life. You know, and because of the terrible medical care he receives in prison, he right now is waiting for a heart transplant. You know, and because he got substandard medical care for those 27 years. So this is what we're dealing with, folks. Okay, on a lighter note. So our work at the Innocence Project of Florida is more expansive than just DNA cases. Most of our clients over the last decade were freed based on non-DNA evidence indicating actual innocence. And while in most of those cases the crime did in fact happen, and we're just trying to demonstrate that someone else did it, there's a smaller subset of non-DNA cases worth noting, and those are those cases where we can prove that a crime actually did not happen at all. These are two of our former clients, Stephanie Spurgeon on the left and Amanda Brumfield on the right, and both were wrongfully convicted as a result of a death of a small child that was in their care. Stephanie had a reputable in-home daycare, and a one-year-old girl. It was her first day at the daycare. And this little girl unfortunately fell ill after she was picked up by her grandmother. And doctors at the hospital discovered that this child had a brain bleed and brain swelling. Despite this child not having a single bump or bruise or mark on her body, on her exterior, and had a 468 blood sugar level. Okay, so I'm sure if you're in a big room of people, someone's probably diabetic here, you know what that means. Okay, that's 4.5 times, more than 4.5 times the normal blood sugar level. The doctors ignored those signs of some diabetic situation and instead concluded that that child's injuries were from abuse, and because Stephanie was the last person to care for that child, all signs pointed towards her, and that child died 7 days later, unfortunately. So a child abuse pediatrician invented an explanation that Stephanie must have slammed this child repeatedly on the crib mattress, which is why she could have those injuries in her brain, but not any external injuries. And unfortunately, she was convicted and sentenced to 15 years in prison. And Amanda has a similar story. It was going on at the same time in a different county. She was babysitting her one-year-old goddaughter when the child climbed on the rail and fell headfirst out of one of those pack-and-plays, like a playpen. And the child at first seemed fine, if a little scared, but then fell unconscious. And Amanda immediately contacted the child's mother and 911 and telling them what happened. And the child had a brain bleed and brain swelling similarly, and died soon after. And despite this consistent account of how this child, would have gotten this head injury that led to her death, and the fact that the injuries were consistent with that account, doctors falsely stated that the injury could not have come from such a fall, and Amanda was convicted and sentenced to 20 years in prison. Both Amanda and Stephanie were, everyday people. They were both mothers of school-aged children themselves. Neither ever had any history of abuse, and they were mostly upstanding, average members of their community. Yet they found themselves painted as child killers, and this is like the leading cause of wrongful conviction for women, because women find themselves far more often than men in these caretaker situations for children. So we got involved in these cases, and we used consensus science to demonstrate that the child in Stephanie's case actually died of an undiagnosed metabolic disorder, and that the child's injuries in Amanda's case were completely consistent with the fall as described. And we were able to overturn their wrongful convictions by showing that a crime didn't happen at all, that these children just died from either a tragic medical situation or a tragic accident. Not every time a child dies should it have a criminal justice response. They were friends in prison, and they were freed from the same prison 30 days apart in 2020 during the height of the pandemic, and were our first female clients to be freed, both after spending 8.5 years. Now, James and Bill and Stephanie and Amanda represent just 4 of the innocent folks who we represented who have had to endure years locked away in remote reaches of rural Florida. And who were lucky enough to come out the other side of that with their lives intact, with a chance to try to gain back some of what they lost. So in all, my office has helped free 30 individuals, men and women, who have spent over 647 years in prison for other people's crimes. We freed 2 more men this year so far, and we feel pretty confident that an additional 2 to 3 individuals will be exonerated before the year is out. And when we think back to our thought exercise at the beginning of this talk, and we picture our own life being similarly impacted, the loss becomes unimaginable. Yet these men and women that do achieve freedom, after so many years, they have to try and put those pieces back together. They have to both overcome the stigma of a prolonged incarceration for a terrible crime, like rape or murder in most cases, or child abuse. Have to explain, even when they've been exonerated, why that is. And they have to do that despite not having done these things. It's very difficult. It's hard to get jobs, housing, the whole thing. They have trouble building relationships with families and partners. They have to overcome daily struggles of coming out into a world that is completely different than the one they left, in some cases 20 or 30 or 40 years earlier. And I think back to one of my former clients, Al Krotzer, who was exonerated of a Tampa rape through DNA testing in 2006 after he spent 24 and a half years in prison. Now, after a week after he was released, he went for a job interview as a janitor at a local hospital. And he was using the restroom, and he put soap on his hands, and he reached for the handle to turn on the water, but there was no handle. He looked all around, even looked under the sink. Others in the restroom were staring at him, wondering whether this dude was having a mental break. And he had to leave the restroom and ask the person who was with him how to turn on the water, because he had no idea that faucets had sensors on them. And if he were to tell the story, he'd laugh, he'd joke about it. But in that moment, it had to be pretty damn humiliating. Not to be able to do something that a little child knows how to do, that we all just take for granted as a normal thing in our everyday life. And there are hundreds of these stories in the lives of exonerees as they struggle to fully reintegrate back into society, trying every day to add things to their base of knowledge that we just all take for granted. And that's why in 2006, our project hired a full-time social worker to create and implement a comprehensive re-entry program for our clients, which was the first of its kind in the entire country. Our social worker begins working with these clients and their families when they're in prison, before they get out, to set goals for what they want to do, where are they going to live, what job are they going to do, what education do they need, how are they going to get to their doctors, their dentists, their eye doctors, the whole thing. This put skill and expertise in place to address the struggles of reintegration, and has been a key driver to the success and happiness of a lot of our clients, because after all, when we get someone out, we have to move on to the next case. And I'm a lawyer. I don't know anything about, I know by association, but I'm not equipped to handle the daily, weekly, monthly, annual needs of our clients. But we have a social worker who handles that. And because of our work to get them out and help them re-enter society and gain stability, so many of our clients have gotten to experience things at points during their wrongful incarceration they would have never thought were possible. They were just illusions in their mind. Bill Dillon is a country music recording artist. And he also, before he was having his heart problem, he was touring with a band of exonerated musicians who hailed from all over the country. Here, there. They're the exonerated band. And they're awesome. They're so much fun. Derek Williams, who spent 18 years in prison until DNA testing proved his innocence of a 1993 Manatee County rape. He got married to his longtime fiance. They got engaged before he went in. She stuck with him all those 18 years, and then they got married. And we helped him get his commercial driving license, and he's a long-distance trucker now. So he makes decent money. James Bain, who we met earlier, regularly speaks to students and civic groups about his ordeal and his travel to Germany. If you can imagine this, the Germans love James. I don't know why, but they love James. And he's made a series of appearances there, and I got to travel with him on one of those trips to Dachau. And I have a grandchild of 3 Holocaust survivors, and so the connection between his experience and the place we were at wasn't lost on either of us. And I'm thrilled he got to meet my bubby before she passed away. And so and they met like 5 or 6 times and had just a wonderful connection. And she understood the connection between what she went through and what he went through. It's just a difference in degree, This is Dean McKee, who was exonerated in 2019 after spending 30 years wrongfully incarcerated since the age of 16 for a Tampa murder he didn't commit. He was framed by his brother for the murder, which is crazy. He is an incredible artist and always had a dream of, he tattooed in prison, which you're not allowed to do, but he did. And he had a dream of opening his own tattoo shop. And in 2020, maybe right before the pandemic, he opened Inside Ink in Largo, Florida, and so if any of you or maybe your grandchildren want to go get tattoos, I recommend going in. Just tell them Seth Miller sent you, and he'll be really thrilled. So out of tragedy, we've now had this huge community of freed, innocent people who are models of patience and perseverance and dignity. So I want to, spend so much time talking about our work, and I'd be remiss if I didn't mention the new innovative collaborations that we're working with units that are created within prosecutors' offices to also look back at old cases and try to remedy them, which is a new thing. Weird as a defense attorney to work with the prosecutors to try to fix wrongful convictions. But we're currently working on cases with the conviction integrity or conviction review units in Orlando, Fort Lauderdale, Tampa, and Jacksonville. And these involve cases, some of them that we worked up and brought to them, or some that they've worked up and brought to us. And we work on them collaboratively, if you can imagine that. And oftentimes they lead to agreements that we can resolve cases, exonerate people without litigation. So we can hopefully get to the answer more quickly for our clients without having to spend years in court. They're not without complication, because they're still prosecutors and we're defense attorneys, but it has allowed us to accomplish a lot. And it's really a new wave of how to do this work. It cuts through a lot of the red tape. And since 2019, these collaborations have led to the release of 8 of our most recent innocent clients who've gotten out, including Nathan Myers and Clifford Williams, who spent 42 years in prison for a murder in Jacksonville they didn't commit. Robert Dubois, who I mentioned earlier, who spent 37 years in prison for a rape murder in Tampa that he didn't commit. We actually found the true perpetrator in that case. Leonard Cure, who spent 16 years in prison for an armed robbery in Broward County that he didn't commit. Both Leonard and Robert were just compensated by the legislature this session and just got their money within the last month. Tony Hobbs, who spent 31 years in prison for an armed robbery in Tampa, didn't commit. Cornelius Marion, who spent 33 years in prison for a Tampa armed robbery he didn't commit. And most recently, this past March, Sidney Holmes got out, who spent 34 years in prison for an armed robbery he didn't commit. So I think it's worth mentioning, all of you as people who are politically initiated are thinking about this work that is happening by these prosecutors under attack. Okay? The governor took out Andrew Warren, and it is now harder to do this work in Tampa. Okay? In that Cornelius Marion case, they wouldn't agree to exonerate him. They'd only agree to let him out, which of course we took because we wanted him to be free. And in order to do it, we had to agree not to talk publicly about it, like in the press. I can talk to you about it. So you go on the internet, there's not a single article, not a single thing about Cornelius Marion except his prison photo. Okay, so how undignified is that? And that's because Andrew Warren is not there and a DeSantis hack was put in his place. We had a meeting on a Tuesday with the Orlando Conviction Review Unit to talk about progress in 2 cases that are probably, in theory, would lead to exoneration. We got new evidence of actual innocence. On Wednesday morning, the governor removed Monique Worrell, the elected state attorney. And we don't know whether that unit will exist any longer. So, 2 steps forward, 10 steps back. But we keep moving. So, I want to leave you not leave you, I'll finish my talk and take some questions, but I want to just end with an anecdote that puts a fine point on the impact of our work. So I was at a conference with James Bain, who you saw. It was the big Innocence Network conference. There's like 300 exonerated people there and their families and all the people who do this work all over the country. And our 2 families, his family and mine, were there, and our sons, you saw a son there, they were swimming in the kiddie pool together. James' son is now 11 years old. My son will be 11 next month. They were born 6 months apart, and they were 3 years old at the time. And here, him and I were two of the maybe unlikely, people to be connected, and here we were. Our paths crossed through this crazy set of circumstances, and we were now watching our children play together. And he turns to me and says, "How unlikely is this?" He's like, sometimes he's like very intuitive and something very profound. He says, "How unlikely is this? But for you, this never would have existed." And I'm like, okay, thanks, that's heavy, we're at the pool. But yeah, it's truly a privilege to do this justice-driven work every day with Jessica and the rest of my team back in Tallahassee. You can literally give people their life back, and it's been an honor to be here today to share this experience with you, and I'm happy to take any questions, so thank you for having me. Sir in the blue hat.
So I think of Henry Fonda's movie, 12 Angry Men.
Yes.
But my question, when I hear your talk, question on the disproven methods of forensics, does that include fingerprints?
Depends who you ask. So the question is, when we talk about, I'll try to repeat the question, so the question is, we talk about unvalidated forensic sciences, does that include fingerprints? If you read the National Academy of Sciences report and the PCAST report, they include fingerprints as not having a valid scientific foundation.
At all, or as much?
So the issue is that when you have these pattern matching techniques, all it does is rely on the person who's looking at it and their experience. Like with DNA, they have validated the method and reproduce results over and over and over again. And as a hallmark of the scientific method, reproducibility means reliability. But what they've done these studies where they give the same fingerprint comparison to like 100 different fingerprint analysts, and they get all different results. And so that's the problem. So they're not saying that fingerprints are junk, they're saying that as of this moment, they don't have sufficient scientific foundation to be reliable in the same way that DNA is. That doesn't mean that they can't get there if the fingerprint community does the work to validate the method, to come up with a scientifically valid method. They haven't done so yet, but there have been judges that have tried to exclude fingerprints post these studies, and they've been overturned by the appellate courts. So the court system is not willing to take away fingerprints as a tool as of yet. However, as a defense attorney, if you're at a trial and you're intrepid, you can use the things that we've learned about the problems with fingerprints to try to undercut the jury's reliance on them in cases, but that's a case-by-case thing. So, ma'am, right here, and then we'll go in the back, okay?
So I have a question about how this comes about, or how the incarcerator knows about you, or you seek them out, or how does the connection occur, since there's so many people that this would apply to?
Yeah, so the question is, how do we find our clients? Okay?
Or they find you?
Yeah, or how do they find us? So in all different ways. The primary way is that people write us handwritten letters, okay? And we have a team of 3 full-time people that all they do all day is do intake and screen cases, and work them up for us to figure out whether we're going to take them or not. So one way is people write us. Now, it used to be we get faxes from family members. Now we get Facebook private messages, we get tweets, we get phone calls, emails, the whole thing from family members. And we tell them the person has to write us unless they can't write or read or something like that. We also find cases. So for example, if we, with that John Preston, the dog handler, when we identified this dog handler was fraudulent, we went back and found every single case that he testified in, starting in Brevard County, and we litigated a number of cases we didn't win any of them, but we litigated a number of cases in hopes to overturn those convictions. That's sort of the more proactive way to do it. And we would do the same thing if we found like a crooked cop who had systemic misconduct, or there was a method used, it was like a microscopic hair comparison. A hair is found at the scene, they put it under a microscope with a hair from a suspect, and they say, it's the same. Well, that's been deemed invalid by the FBI. And so we went back, working with the FBI and the Innocence Project of New York, we went back and looked at every single one of those cases in Florida and overturned some convictions based on the material use of that evidence. But also, prosecutors bring cases to us. We've had the parole commission call us and say, hey, this person, we're considering for parole, but we think there's an innocence claim here, you might want to look into it. Our investigator was at a prison interviewing a witness, and the classification officer stopped her and said, aren't you from the Innocence Project? I have a case for you, this is someone at the prison. And of course, we see news articles. Like Jane Spain's case is the craziest thing. Like, I was going to Thailand on vacation in 2009, in March 2009, and we have this thing called the Florida Law Weekly, which is like a little booklet where they release every week all the appellate opinions from like the previous week. And so I was like a month behind, so I took my stack, I got a long flight, I'm gonna read the Florida Law Weeklies to catch up. And so I'm on the flight to Seoul, Korea. And I like read about his case, that they were sending him back for an evidentiary hearing, and he was not gonna have a lawyer, and he had already been denied 4 times by the same court. And so when I got to Seoul, Korea, I called my office and said, I'm gonna be gone for 2 weeks, figure out everything you can about this case, and then we'll talk about it. And we got in touch with him after. He said, do you want our help? He said, yes. And then we took on the case, and 8 months later, he was free. And so, really any different way. We're just always looking, and people are always looking for us. We try to meet in the middle. Man in the glasses in the back.
I was just wondering, how much, is there data that shows how much the advent of DNA technology has reduced the wrongful convictions? And is that an issue? I mean, is that, I'm sure it's been helpful, but are there studies that show how much impact that has had?
So I don't know about studies that, so the question is, are there studies that show the impact of DNA on reducing wrongful convictions? So I think the question refers to, has DNA had an impact on preventing them in the first place? I don't know the answer to your question, but here's what I would say, is that our experience now, like for the first 10 years of our existence, 9 years of our existence, we only did DNA cases, and there were plenty of them. But as time has gone on and more advanced DNA testing is available on the front end in every case, there are less and less cases on the back end that need DNA testing. And so our focus has shifted, almost entirely to cases that have nothing to do with DNA. And so what I would say is that DNA testing has given us a window into the problems, the things that cause wrongful convictions, but traditionally DNA has only been a feature of about 10% of cases that are going through the system. So those same things that cause wrongful convictions in the cases where DNA can overturn a conviction, they cause them in the cases where DNA is not a factor. And so we kind of said, hey, look, we need to get with the times and really focus on those other 90% of cases. We still do DNA cases, but they're just much more rare. I would say that the one vagary that exists with DNA testing is that because DNA testing is so sensitive now, oftentimes we get very complex results that are hard to interpret. And so the fight now is about when can we interpret those results, and how do we interpret them when we can. And while DNA, the testing itself, is like a reliable methodology, the interpretation is not always reliable. And so we oftentimes get in fights about how they're doing the interpretation and then what conclusions they're drawing from the interpretation. That can lead to wrongful convictions as well. Man right here.
How are you funded?
It's a great question. The question is, how are we funded? And we are funded through a mix of private and public grants, as well as gifts that are given to us, donations by generous supporters, both just solicited or unsolicited, but also through events that we have. And so we have a budget right now that's about $1.2 million in expenses annually. We have 10 people working on our project. We provide all of our assistance to our clients for free, every bit of it. So we just spent, we overturned a conviction in May and got relief for our client, and we spent, in that case, $35,000 in experts in the case. It was a very complicated arson case. So that is not the kind of high-quality assistance and well-resourced assistance that our client got at trial. But it was and is the assistance that he deserves to get to the truth. And so we're committed to doing that and raising the money to do that. So the Florida Bar Foundation, which is the philanthropic wing of the organized bar here in Florida, they fund us. We've got a number of Department of Justice grants through the Justice for All Act, which funds programs like ours, and then a lot of private foundation grants of various different sizes.
And may I interject? There are materials on this back table about the project and donation envelopes if anyone is so inclined.
I hope you're so inclined. Yes, sir. Yes.
What do states do with the incarcerated people when the state reverses, like with marijuana, you have a small quantity of it, you go to jail, are they automatically released? How is that handled?
Okay, so the question is, when the state when someone is in prison for something, and then the state changes, let's say, changes the statute to no longer make that an offense, do they just automatically get out of prison? And the answer is no. Okay, so clearly, if in your example, if you were you don't really go to prison for marijuana, you might go to jail, but say you were incarcerated for a marijuana-related charge that is now no longer an offense, you would have a ready-made motion to file straight away to say, you have to overturn my conviction, and your conviction would be overturned. In some places, like in Washington, for example, when they made marijuana legal or they decriminalized it, allowed recreational marijuana, there wasn't that effort. Different prosecutors, if they were politically inclined, were going back and finding the cases, whether the person was in or not, and vacating those convictions, because even if they're not in, the conviction can have a material impact in their life. But it was, I think, the governor, either in Washington or Oregon, I forget which, who then pardoned all of them, right? And so that would be the right step to do. But absent that kind of political intervention, I mean, it's going to be up to people on an individual basis to figure it out, which is unconscionable. If you change the way, I had this is sort of related. We had a law in Florida that said if you had a certain amount of oxycodone or hydrocodone, pain pills, you had to get a 25-year minimum mandatory sentence. And as anybody knows who's broken their arm or had a surgery, the doctors readily give this stuff out to anyone. And people, average people, get addicted to it simply because they were prescribed it by their doctor. And so the people who were getting convicted of these things weren't drug kingpins, they were just people who had pain management issues. And they had to get 25-year sentences. But they changed that law in 2014 and 2019 to make it a 7-year minimum mandatory, pretty substantial reduction. But all those people who got convicted in 2003, 2004, 2005, they're still in prison. And no one went back to fix it. So we did a special project, again, sort of out of our normal bailiwick what we do, but we did a special project at the beginning of the COVID pandemic. We're really concerned about people in prison and didn't really know what COVID was going to do to the prisons. We did a special project with the prosecutors in Broward County to go back and identify all those people. And we had some arguments about who they were still making determinations based on character assessments of people, but we were able to agree to release 25 people who would not be in prison any longer if the current law was in place, which, it's not 500 people, but 25 people for those people is very important. And so, so I got to call a bunch of people up and say, you can get out tomorrow. You know, and, I mean, they weren't expecting it, so it was really a treat.
What happens if somebody doesn't want to take DNA testing when they find that they committed something, like the man in New York who refused to take DNA testing, that murdered the women and raped them in Long Island?
So are you
Is
talking?
there a law that says they have to take DNA testing?
So, let me just see if I understand the question. You're asking, is there a law that people have to take DNA testing? So to be clear, in Florida and in everywhere in the United States, when someone is convicted of a felony, at their sentencing, the bailiff, the sheriff's bailiff or whatever, swabs their mouth, inside their mouth, puts in envelopes and sends it off to FDLE to be tested and put in the DNA database, state, local, national.
This man had a pizza box that they found
Okay.
in New York City of DNA, but when they wanted to take, to have a case, they wanted to do DNA testing.
Are you talking about, just let me clarify, are you talking about his trial lawyers, or he applied to like the Innocence Project, or what was the?
He didn't do anything.
What she's saying is that the person that is the principal subject in the Gilgo murders on Long Island has refused to allow his DNA tested prior to continuing the investigation. The suspect.
Yeah, but that's really suspect, right? I mean, so I don't know the answer to your question about the Gilgo murders, but what I would say is that, and again, we don't do a ton of DNA testing cases anymore, but when we did, we would go to see the client and say, look, we would call it the come to Jesus talk, and we'd say, look, I don't know what you think about DNA testing, but if your biological material is, in that victim's orifice, it's going to be on the swab from that orifice. And so we can test this, but if there's any reason that we shouldn't test it, that your DNA is going to be there, now's the time to tell us. And so, well, mainly because, I think there's, people are desperate. I understand why someone would want to, maybe they get a silver bullet, right? But there aren't really silver bullets with that science. And so we've had a couple cases where the person said, yeah, now that you mention it, maybe I don't want to do the testing. And we're like, cool, thanks for saving us money. But we have, I would say, I don't know how many we've done, but if we've done 100 DNA tests, probably 30 of them included the person as perpetrated, proved their guilt. And so that happens. I wish they wouldn't waste our time, but sometimes they do.
So you're saying Trump is going to get DNA tested?
So I don't know what I don't know. Hold on.
Just curious.
Yeah, I don't know what the feds. That's a saucy question. I don't know what the feds do, but if it's like everywhere else, if you get convicted of a felony, they would swab you and you would get sent off for the testing. Yes, sir, right here.
When I lived here in the 80s and 90s, the state had a unit, I think, for capital crimes, where they went back and looked at the capital crimes. Do they still have that unit?
Are you talking about the Capital Collateral Regional Council, the CCRC? Like the people, the defense lawyers who would represent people on death row?
This was a state organization.
Yeah,
It was funded by the state.
They're funded by the state, but they're like a public defender for death row inmates that have already been convicted and sentenced. Yeah, if that's what you're talking about, it still exists, yes.
Oh, okay, all right.
Yeah. So just to be clear, a lot of people think that they say to me, oh, we're talking about death row, but we don't do a lot of death penalty cases because in Florida, those people all have right to counsel. All throughout, all the way through execution, so it's more like a resource management allocation issue. We work with them and co-counsel cases with them, but principally our work is for people who are not in death row. Yes, sir.
Yeah, thank you very much, Seth, for this very informative presentation. I have a question now. For all the people that have been wrongfully imprisoned for years and years and years and then become exonerated, do they get any kind of compensation whatsoever from the state?
Okay, so we hear the question, do people get compensation for their wrongful incarceration? So different states some states have no compensation provision. I think like 30 some odd states do, and they vary in the level of generosity. Texas, unbelievably, has the most generous compensation law. Florida's was generous, probably when it was was in the mainstream when it was passed in 2008. It provides $50,000 a year for each year of wrongful incarceration, but it has not been updated on the amount, and so it's fallen behind, I think, the average among other states. The thing in Florida that is unique to our state is that our compensation law has what's called a clean hands provision. So what that means is that if you were convicted of either a serious felony or more than one non-serious felony previous, unrelated to your wrongful conviction, and then you later get exonerated from your wrongful conviction, you cannot get compensated under the statute. So it's like, because we think you're a person of bad character, we're absolved of giving you remuneration for this thing we did to you. And so we have tried mightily for 15 years to fix that. We were there this year. It passed the Senate. We were in our last committee in the House when they wanted to. We talked about prosecutors like this that have these conviction review units, progressive prosecutors, and because Ron DeSantis is on a kick about these anarchist prosecutors, we all of a sudden were first hearing for the first time that they want to amend the bill to require that if the prosecutor's office agrees to the exoneration, i.e. those anarchist prosecutors, if they agree to the exoneration and when the person applies for compensation, that prosecutor's office has to conflict off and the governor gets to appoint a different prosecutor's office to deal with the compensation. And of course, they will, appoint like your prosecutor here in the Fifth Circuit, and the person will not get compensated. And so so we killed the bill. We killed the bill. So the way that a number of these other people got compensated is they filed individual claim bills just for them, and they passed a specific piece of legislation just for them. But sometimes that takes 2 or 3 or 4 sessions to build the education and political movement behind this one person, when we could just change the law and make it apply to everyone. So it's a huge problem. I've been working on it for 15 years with no success. So, yes, ma'am.
Can you address the public defenders of these people that were wrongfully convicted? I know they're under strain, and I know it's usually pro bono. What happens to those people that really didn't take care of their clients the way you should?
So I have a joke for you. And the joke is that invariably I find that people are getting better representation by public defenders than private attorneys. Oftentimes. And there are amazing private attorneys too, but in cases that are serious, that require substantial resources to litigate, you might be better off with a public defender because once they have money to draw from, right? But once you run out of money to pay your private lawyer, there's no more experts, there's no more investigation, unless the person is very generous and willing to start paying out of pocket for those things. And so, Stephanie Spurgeon, for example, here, had wonderful, private attorney. Wonderful private attorney who fucked up the case. Yeah. And it's because she ran out of money. And because she had hired 2 previous attorneys and lost $150,000 in hiring them, and just only had $50,000 left, and that wasn't enough money to litigate the case. And so, look, I'm a defense attorney. I have a lot of sympathy for how hard it is to do trial work, and it's very easy for me to come behind, or my staff come behind and armchair quarterback. It's easy to see it 20 years later. And I think the law, when we go back and we think about it, contemplates this idea that we want to give professional latitude to lawyers to litigate the cases in the way that they think is best, so long as they thoroughly investigate the case and make informed decisions about strategy based on a thorough investigation. Where I think they get in trouble, and we have a number of cases like this, is where they don't do the investigation. And then they come back later and say, well, you know, they make up a reason why they didn't do this or that. And so we've caught a lot of defense attorneys, you know, in that. But then, you know, they get an opinion that says that they were constitutionally ineffective. And I don't file bar complaints against them, and maybe I should, but as far as I'm concerned, like, you know, the prosecutors are the ones who decide to charge the cases. The prosecutors wrongfully convict people, and there's not enough bar complaints filed against those folks. So, yes, sir.
When you get a birth certificate, it might show a footprint of the child.
Yes.
Would you be in favor of the fact that DNA is so accurate, having DNA on all births?
You know, I think there's civil liberty concerns with these sorts of things. I mean, I'm not the ACLU. I will say that I think we've gotten pretty far afield. I think that, you know, we started collecting DNA samples from all convicted offenders for felonies. That's pretty standard across the United States. But now many states have started collecting DNA samples to put in the database from felony arrestees for certain enumerated felonies. In some places, they collect DNA from misdemeanors. And I suspect there is a place where you know, the value in that is outweighed by the civil liberty concerns. I just don't know where that spot is. I mean, I think the phone call agrees. You know, I think collecting DNA samples from misdemeanors and arrestees is certainly problematic, and yet the Supreme Court has found it's not problematic. I don't know that what I think personally matters. What I would say is that, like, would it be wonderful if I'm trying to solve a case, in one case, to have every single person's DNA in the world where I could put the unknown DNA in and find the real perpetrator? Yes, that would be incredibly helpful. But I'm wondering whether the benefits of that one person would be outweighed by the detriment to many people who are ensnared in things that they have nothing to do with. Because you can imagine, you get DNA on an unknown DNA on a piece of evidence, maybe there's a good explanation for why that person's DNA is there, and yet if you get a hit in some database, they might be ensnared in something that they didn't do. It could cause people to be wrongfully convicted. So, yes.
With AI working its way into every aspect of our life, I mean, I have really mixed feelings about AI, but how do you foresee AI marrying up with forensic science? Or is that already happening?
I mean, I imagine, well, I don't know. I mean, I imagine there's going to be some, like, confluence between AI and certain, like, identification softwares that they use to, like, visual identification, face identification softwares that they use. I honestly don't know a lot about it, to be honest with you.
Yeah,
it's all a little scary to me. Like, I love science fiction, but I have to, like, watch sports after I watch Black Mirror because I need to, before I go to bed, because I need to clear my head or all of nightmares. So, did you hear your question?
I know that you could have spent just as long about the criminal justice system prior to any conviction. That is, so many in the whole nation, so many crimes are designed and intended to target people of color and minority populations. That's the way it was set up. So many stops that are pull people over. There's a whole system in place, including lack of supervision of prosecuting attorneys, so that it's not a transparent system. There's a whole system in place that essentially speaks very silently of the Jim Crow system. And so all the work doesn't fall on you. A lot of the work falls on other organizations that are trying to prevent these convictions in the first place.
Well, I think that's right. I mean, we're one piece of it. We're and again, people always want me to come speak, and and it's great, and I think the work we do is really important. And Jessica's going to kill me. He says, I don't know if it's the most important work, right? I mean, it's a part of the broader important work that needs to be done to make a more fair and just system. And we need to better fund public defense. We need to have I can't tell you how important it is to elect the right people as prosecutors, or elect the right people as judges, or elect the right people as sheriffs. I mean, we have this feeling about what those people should be, instead of thinking about what they can be and how they can better serve the people in their communities. I mean, we complain about, the overbroad use of prosecutorial discretion. Let me give you an example. In Leon County, where I live in the 2nd Judicial Circuit, this prosecutor, the new prosecutors, working in like misdemeanors, and she was told that there's a policy that depending on like the nature of the person's background, they would offer a diversion program or not. And like one of the criteria where they would not offer a diversion program was if the person had a number of other prior misdemeanors, seems fine, or they were Hispanic. It was on the wall on the sheet. And so this person quits, kudos to them, and you don't get another job, okay? You're a lawyer, get another job. And they quit, and they, whistle blew. Right? It matters who you elect as your prosecutors. Like if you don't want, if you want to cut into systemic racism, then you need to elect prosecutors who want to cut into systemic racism and not perpetuate it. And so I do think like there's structural issues that are kind of, this is all rooted in, that we have a lot of work to do, and like the work we're doing is really just kind of, in some ways, nibbling at the edges. I think the most important work we do is the policy work we do to change how things work, because that's going to really, to your point, really undercut some of these bigger problems as we go forward in the future. Yeah, I'll take one more if anybody has them. Yes, sir?
The exonerated people, do they get their voting rights back?
Depends. We talk about Jim Crow, right? So James Bain, Dean McKee, Stephanie Spurgeon, Amanda Brumfield, they didn't have any prior felony. They had no prior felony convictions. So, when the conviction got overturned and went away, that was that. So yes. But for the people who did have prior felony convictions, let me be clear, if you have prior felony convictions, you are more likely to be wrongfully convicted because you are more likely to become a suspect in a future case. And so here we are, like, we're blaming the exoneree for their own wrongful incarceration. We don't compensate them, and then when they get exonerated, we don't allow them to vote, right? And so, for example, if one of our clients had, $500 in unpaid fees, and that was the bear, we would just pay it for them. So we raise money for such things, but they would be labor under the same barriers, that are put on anyone who comes out and has, a prior felony record. It's unconscionable. But let me be clear, we work with all of our clients to make sure they have health insurance, they have, a stable place to live, they get their voting rights back, the whole thing, because we want them to have a fullness of the freedom. Okay, thank you so much, guys. Appreciate it.
So I did have one question I want to ask, and that is with the weather's been really bad, really hot, and are all the prisons air conditioned?
No. And so the prisons that are air conditioned are generally the ones that have been like privatized. So, so the ones that are privately run have air conditioning. If you go to like the administrative offices in the prisons, yes, the people who work there sit in air conditioning, but I mean, I've been talking to some of my clients in this past heat wave, and they're not. I mean, it's crazy, totally crazy.
Thank you for a great presentation.